My name is Dr. Stephen Scoltetti, and I'm a member of the faculty at the University of Mississippi, where I serve as director of the Declaration of Independence Center for the Study of American Freedom. The mission of the Declaration Center is to ensure that students, faculty, and citizens across the state of Mississippi have an opportunity to study freedom in an academic manner. Now, many times when I tell people about the mission of the Declaration Center, the first question they ask me is, well, what do you mean by freedom? And it's true that freedom can mean many different things. Perhaps the most familiar theory is that we're free when our actions are not interfered with. But that's not the only theory. Another one is that we're free when we're members of a community whose members are not subject to arbitrary or capricious uses of power. This is known as freedom as non-domination, or it's sometimes called Republican freedom. Now, how do you go about ensuring that the members of a community are not subject to arbitrary uses of power? A classic answer to that question is that you take steps to ensure that that community abides by some kind of constitution. And that's why it gives me such pleasure to help organize this year's Constitution Day event at the University of Mississippi. This year, we invited a panel of guests to discuss the significance of recent Supreme Court decisions that have bearing on our constitutional life together. I'd like to thank the University of Mississippi School of Law, who helped me to organize this event. I'd also like to thank the Jack Miller Center for teaching America's founding principles and history, whose generous support helped to make this event possible. And finally, I'd like to thank each of the panelists who attended and participated in this year's event. First, Professor Gail Harriet. Professor Harriet received her JD at the University of Chicago, and she currently serves as a professor of law at the San Diego School of Law. Next, a word of thanks to Professor David Bernstein. Bernstein received his JD from Yale Law School, and he currently serves on the faculty at the Antonin Scalia School of Law at George Mason University. And finally, my colleague, Dr. Christopher Green. Green received his JD at Yale Law School, and he also has a PhD in philosophy from the University of Notre Dame. Professor Green serves as a professor of law here at the University of Mississippi. I hope you enjoy this Constitution Day event as much as I did.
This year's term at the Supreme Court, I think, was extremely important with respect to their equality cases. A year ago, they had a bunch of cases about fundamental rights. So, of course, Dobbs and Bruen, the gun case, talked about the nature of how you figure out what a protected liberty is under the 14th Amendment. Lots and lots of stuff about tradition. This year, several cases about equality. I don't know which of the cases will get how much attention, but of course the biggest one, huge, titanic, is Students for Fair Admissions versus Harvard, which may or may not have overruled Grutter versus Bollinger from 20 years ago. That's certainly something we can talk about. A second big case, 303 Creative versus Alanis. So this is a First Amendment case. It's about a case about compelled speech, but this was a lady who wanted to run website services for opposite-sex couples, but not same-sex couples. And the Supreme Court said that if Colorado required her to also provide websites for opposite-sex couples or for same-sex couples, that would be compelled speech. So this is a follow-on to the Masterpiece Cake Shop case from 5 years ago. Notwithstanding the arguments for equality as a countervailing interest. So equality is certainly, I think, an extremely important part of what's going on in 303. Third big case, Hayland versus Brackeen. This was a case about the Indian Child Welfare Act there were three main challenges to the act. So this is an act that gives special procedural rights to tribes or to other to individual Native Americans with respect to the adoption of Native American children. And the court said that this is within federal power. So Congress passes this law in 1978. The court says that is within federal power, and it does not improperly commandeer state administrative apparatuses, but it may or may not be improperly discriminatory based on improper use of racial classifications. They said there's no standing for that, and the extent to which that argument is a winner is something that is worthy of some discussion. Justice Kavanaugh was very clear in his concurrence that he thinks this is pretty clearly a winner. After SFFA, I think it's even more clearly. But that kind of sets the table for some important issues to come, as well as addressing some very important issues just in the issues it did cover. A couple of other statutory cases. There's Groff versus DeJoy. This is a unanimous case that decided that the standard under Title VII for religious discrimination, so Title VII of the Civil Rights Act of 1964 says you can't discriminate on the basis of religion, and you have to give accommodation to religions if doing so would not be a substantial burden. And substantial is defined, it seemed, everybody thought in 1977 that it was defined as anything more than de minimis, but the court unanimously said, no, that's not what it is. Justice Alito said some things about it that are maybe a little difficult to decipher at first blush, but Groff is an important Title VII religious discrimination case. And then finally, a very important statutory case, Allen versus Milligan, is a Voting Rights Act case about the duty of states to redistrict, to draw congressional lines especially, in a way that will allow more majority-minority districts to elect members to Congress. So lots of, it was a very long case, following many earlier precedents, which are very long cases. So if you have some caffeine available, you may want to keep it in reserve if Allen versus Milligan comes up, because there are some details, let's just say. Those are, so I just wanted to set the table about what cases we're talking about. But Gail, if you want to say something about one or more of those.
Okay, I'll give it a try. I know that law students love it when their law professors can summarize 5 Supreme Court cases. Bear in mind that's 400 pages worth of reading in just a few simple sentences, tied up in a neat bow. Maybe David will be able to do that, but I am not sure I can do that at all. Sure, all 5 of these cases deal with issues of equality, but the issues are very different. They arise procedurally in very different ways. The court deals with them in different ways, and sometimes the court just dodges the equality issue altogether. I usually don't like scorecards when talking about Supreme Court analysis. You know what I mean, sort of like how many wins, how many losses, and such. The law is a whole lot more complicated than that. But in this case, given the talk in the popular press and given some of the talk about the possibility of court packing, I think maybe it would actually be useful for me to give you a little bit of a scorecard here. So here goes. In two of them, you get the 6-3 split along the usual right-left lines that journalists and politicians are getting a bit agitated about these days. Those 2 cases were the Students for Fair Admissions case and also 303 Creative. In one of them, as Professor Green just said, Groff versus DeJoy, it was actually unanimous. That is the Title VII religious accommodations case. The other two were a bit more complicated. One of them, Allen versus Milligan, the redistricting case, that was a 5-4 nail biter with two conservatives, that is Roberts and Kavanaugh, defecting to form a majority with the three progressive justices, thereby making a majority. But the other one, the Indian Child Welfare Act case, that was an odd configuration, 7-2, with most of the conservatives in the majority, along with the three progressives, but two, that is Thomas and Alito, in dissent. And what was interesting to me about that case, well, first of all, the equality issue didn't get decided at all in that one. Rather, the issue that was before the court and was actually decided was on the issue of the congressional authority to even legislate in the way that they did about tribal matters. And you get an interesting discussion between Gorsuch and Thomas, both of them conservatives, both of them looking at the constitutional issues in a way that I think they would characterize as originalist, but coming to radically different conclusions. And to me, that makes for interesting reading. These guys are obviously not carbon copies of each other. On the other hand, the only constant that I saw in all 5 cases was the 3 progressive justices, that is Kagan, Sotomayor, and Jackson, are always together through thick and thin. Now, it is worth noting that these 3 progressives were in the majority, a majority of the time. But that doesn't mean that this has turned into a progressive or liberal court, not by any means. All the justices were in the majority, a majority of the time. I think that's actually kind of a good sign. And Roberts and Kavanaugh were always in the majority. I think it's important to note that in the cases where the 2 cases that were the conservatives were in dissent, the opera may not be over in those 2 cases. There are still unresolved issues. In the Indian Child Welfare Act case, Howland versus Brackeen, the racial equality issue, and that is the question of whether prospective foster or adoptive parents who are non-Indian, are they being discriminated against on account of race? That issue was dodged by the court. The majority ends up saying that the plaintiffs sued the wrong defendants, rather the individual plaintiffs sued the wrong defendants, and that the state of Texas itself did not have standing to litigate that issue. But the court's not going to be able to dodge that issue forever. So the act may yet be found to be unconstitutional. And in the redistricting case as well, there was again an unresolved issue. Justice Kavanaugh, who was in the majority, was careful to point out an angle of the case that he did not think had been brought up by the plaintiffs. He therefore thought that it was inappropriate for the court to decide the issue. But it's a temporal issue, and that is whether the part of the Voting Rights Act that prohibits disparate impact, can that be relied upon by the court forever and ever in order to order race-based redistricting, now being nearly 60 years after the passage of the Voting Rights Act of 1965. So that issue did not get resolved. When that issue was brought up, who knows? Maybe the 5-4 case will go 4-5 in the other direction. My point here is simply that the court is not leaning dangerously to the right here. We're in fact seeing the majority of justices, or all the justices in the majority for all of the cases. So we're not seeing something that is going wildly to the right. At the same time, there is a drift towards more conservative directions, but it's at a pace that is perfectly ordinary. That is situation normal. So much for the scorecard. On a somewhat more substantive note, one of the striking things about these 5 cases is the court's reluctance to overrule precedent. There are probably several reasons for that. First, respect for precedent is what you expect from a conservative court. Conservative courts are supposed to value stability in the law. Granted, that approach can be in tension with originalism, which holds that in interpreting the Constitution, or a statute for that matter, one should try to determine how it would have been understood at the time it was adopted. And that can be, in its strongest forms, originalism would be regardless of whether later courts have made mistakes in interpretation. Still, in general, I think it is accurate to say that conservative judges will tend to be more respectful of precedent than progressive judges. And it's certainly the case that there have been fewer cases overruled in the last decade than in the decades when the court has leaned more to the left than it does now. Second, the precedents that were at issue this year were for the most part interpreting statutes rather than the Constitution. And courts tend to be particularly inclined to stick with their original interpretations when dealing with interpretations of statutes. They figure that if they make a mistake in interpretation, that Congress, or if it's a state legislature, the state legislature can set them right. They can repass the statute, amend the statute to clarify what they meant. So if Congress or a state legislature hasn't done so, they stick with their statutory interpretations. I think Students for Fair Admissions is the best example of this don't overrule the precedent trend, although I think the phenomenon is actually present in at least 4 of the 5 cases. I bring up Students for Fair Admissions in particular because I would have done it the other way. I would have overruled the precedent. And that and $3.25 will get you a cup of coffee at Starbucks. But I'm a law professor, I'm allowed to give my opinion on a Supreme Court opinion. As I see it, there were 2 basic routes the court could have taken, the statutory and the constitutional route, with room for variation in each. They took the constitutional route. I would have preferred the statutory route because it's dead easy. Title VI of the Civil Rights Act of 1964, in my humble opinion, clearly and unequivocally prohibits race discrimination by recipients of federal funding. If so, no one denies that Harvard and the University of North Carolina discriminated and that they received federal funds. The constitutional issue is going to always be harder. The Equal Protection Clause doesn't use the word race, so it's more work to interpret that and more room for disagreement, I believe. The thing standing in the way of a nice, clean, obvious holding that Title VI bans race discrimination was the 1978 case of the University of California Board of Regents versus Bakke. In that very splintered decision, 4 justices took the obvious position, that is, Title VI outlaws race discrimination, period. But 5 justices essentially said, well, it says no discrimination, but we don't think it really means that. There's a lot of room for flexibility here. Okay, maybe I should not be this harsh on Supreme Court justices, 5 of them who are now all deceased, I suspect, so maybe I shouldn't speak ill of the dead, but that was complete baloney. They all knew what the statute said. They all knew what was intended. The reasons they gave for their decision, I think, were unusually weak. My read of the Bakke case is that 4 of them simply disagreed with Title VI's clear mandate, and they just wanted to interpret it away. My read of the 5th justice, Lewis Powell, is a little different, and again, this is just my speculation. He was a mild-mannered, don't make waves type, the sort of person who might be elected president of the ABA. In fact, he was elected president of the ABA. A nice man, a gentleman, wonderful in many ways, but footnote to history, this was not the first time Lewis Powell acted this way. He did the very same thing when he was head of the Richmond, Virginia School Board. He dragged his feet in this case, about complying with Brown versus the Board of Education. So now he was dragging his feet in a different direction to a different group's benefit, you could say, but I think wrongly so. I love gentlemen like Lewis Powell. I suspect I would have gotten along with him very well, but sometimes you need someone a bit more tough-minded to interpret the Constitution, or to interpret, in this case, Title VI. So I would have preferred to decide the case based on the statute. Sure, courts don't like to overrule earlier interpretations of statutes, but they're also supposed to avoid deciding cases on constitutional grounds if they can be decided on other grounds. So, that's the way it happened in Bakke. So the majority in the Students for Fair Admissions case took the constitutional route instead. Not an originalist approach, I would not say, although Clarence Thomas has a concurrence, but an approach that required the court to look at the precedent interpreting the Constitution on the issue of university admissions. Here again, I think the right thing to do would have been to overrule precedent explicitly, but again, they did not. The important case they had to grapple with was Grutter versus Bollinger, a 2003 case against the University of Michigan's School of Law. Like all modern cases involving race discrimination, Grutter applied strict scrutiny, which is supposed to mean that the court conducts a searching inquiry to ensure that the school, in this case, again, the University of Michigan School of Law, has a compelling interest that requires it to discriminate, and that its policy is narrowly tailored to achieve that interest. The presumption is supposed to be strongly against any sort of race discrimination. But instead of conducting a searching inquiry, the court did, well, it explicitly used the word deference. It deferred to the University of Michigan School of Law. Essentially, it said, hey, you're a university, we defer to your judgment. You run a law school, you know what it's like to be in a law school, we're going to accept your judgment. Well, imagine if they'd said that in Brown versus the Board of Education. At the time, there were many professional educators, not to mention the particular board involved in the case, who deeply believed, or at least they said they believed, that segregation was a compelling interest. And they might not have used that term always, but yeah, they would have said that and did say it. If they deferred in that case, we might still have to be dealing with Jim Crow. My point is that deference is the opposite of strict scrutiny. Grutter got partially overruled in the Fisher case, but as far as I'm concerned, this deference idea needs to be explicitly disavowed. It is poisonous, but the court this year didn't do it. It danced around the case and said, well, neither Grutter nor Fisher nor Bakke meant to say that discrimination of this kind could go on forever. And I think that's a fair reading of those cases. The court concluded that it had gone on too long, and the court added that this was never supposed to unduly infringe the rights of others, which I think is an odd statement to be making, since race preferences always infringe the rights of others, but whatever. So I understand the court's reasons for not wanting to overrule past cases, but for my 2 cents, they should have done it in that case. What will happen in the future? Well, we're going to have to wait and see on that. I think there's going to be a lot of issues that come up. There are already schools that are, I think, sometimes trying, in fairness, to comply with the law, but they haven't quite figured out what it is yet. And sometimes I think that, not all of them are trying to fairly comply with the law. So we'll just have to see. But let me switch over and talk about the other 6-3 case and that is 303 Creative, because that one opens, I think, an interesting can of worms. This is a free speech case. Some people have been talking as if they believe this is a religious accommodation case, but that's not how the case was decided. It involves a woman who wanted to have a business designing wedding websites. I think you probably know the sort. They have like dreamy photographs of the happy couple and happy words and you know, poetry to tell the story of the couple's unique love story. You know, everything is going to be specially tailored to that couple. Or at least that's what the petitioner was
Yeah,
saying.
they always invent a portmanteau of the two surnames and
Yeah.
as the name of the celebrations.
You know, and the problem here was that the plaintiff in this case, Ms. Smith, she did not want to create websites for marriages that were same-sex marriages, even though Colorado has a law against discrimination on the basis of sexual orientation by what it calls public accommodations. So Ms. Smith viewed this as forced speech. And it was stipulated in that case, and I think that the stipulation is important here, that you know, both parties stipulate that her work was, quote, expressive in nature, and that these custom websites express her message, celebrating and promoting her view of marriage, and that the viewers of the websites, they will understand this as her original artwork. And to me, that makes sense. It makes sense. I mean, just as the state cannot make children pledge allegiance to the flag in West Virginia Board of Education versus Barnett, Ms. Smith was saying she cannot be forced to pledge allegiance to the concept of same-sex marriage by having her engage her artistic talents in this way. So the court reasons that, you know, it would be different maybe if we were talking about a mere product or a non-expressive service. If a grocery store owner, for example, doesn't believe in same-sex marriage, it cannot decline to sell a box of rice to throw at the happy couple. But you know, that is going to turn out to be a very hard line to draw between what counts as forced speech, expressive speech, and what counts as not that. The Masterpiece Cake case that Professor Green mentioned a moment ago went off on a narrow ground instead of on this ground, but the baker of wedding cakes in that case, he had been arguing that his custom wedding cakes were an artistic expression by him. And, you know, the court was able to dodge that issue, rightly or wrongly. But if a cake is also expressive, what about a wedding caterer? Like any good Calvinist, my hypothetical caterer sees his trade as a calling, as many people do. That's a very, very common attitude by people with many, many kinds of jobs. It's his way of expressing love and appreciation. He caters weddings especially because he feels that his statement that he makes with his catering and the way he designs the food, the way he sets the table, he considers that something that he puts his heart and soul into. Will he be able to make an argument under 303 Creative? I don't know. It is possible that the 303 Creative case will be a one-off because the stipulations in that case were, I think, very strong for the plaintiff. On the other hand, maybe not. Maybe this will be the beginning of a long group of cases that move in that direction. So I think that's all I can cover in 15 minutes. And I actually think that since David has written about this issue more generally in the past, maybe he'll want to say something about 303 Creative too. Or maybe not. Maybe not.
So David.
So this was a very exciting Supreme Court term for me because The three of the cases that we talked about were really right up the alley of my particular interest. So I will talk very briefly about 303 Creative, because in 2003, I wrote a book that I had been thinking about since I was in law school in the late 1980s, which was about conflicts between the scope of anti-discrimination laws and the First Amendment and other constitutional provisions. And there had been a trend in the 70s and 80s with Justice Brennan in particular to say, well, we don't think that this law really infringes on the First Amendment, but even if it did, the government's compelling interest in eradicating discrimination overcomes any sort of constitutional right. And that struck me as just logically problematic, since when do statutes overcome the Constitution? But also basically I would say eradicating anything cannot be done consistent with civil liberties. Like, discrimination is bad, murder is bad. Imagine someone gets up and says, we're going to suspend the Constitution until there's no more murder. You say, oh my God, like, run for your life from the government. So there was a countervailing trend a little bit in the Dale case, and maybe the case involving the marchers in the St. Patrick's Day Parade in Boston, where the Supreme Court said, actually, at least with regard to something called expressive association, where the association wouldn't be able to function the way it wants to if its membership policies were restricted, the First Amendment does overcome civil liberties. But this was not universally welcomed, nor was it clear that that trend would continue. In fact, when I submitted my book manuscript to Basic Books, or my agent did, they said, this is a very well-written, very interesting book, and we might otherwise be interested in publishing it, but this is so contrary to accepted morality. It's like, what morality? All I'm saying is the First Amendment should overcome statutes. Shouldn't be that controversial from a book publisher. So I was very gratified. I think Gail is right in all these issues as to what is compelled speech, what's not. I don't really care about that boundary as such. You could argue about that. But once the Supreme Court says something is compelled speech, the Supreme Court for the first time, I think, really, I wasn't prepared to talk about 303 Creative before Gail teed it up. That's okay. But there's a line there where they specifically say that the argument is that that the government's interest in eradicating discrimination should overcome this right, and they say no, the Constitution wins. So that was very gratifying to me 20 years later, that now this immoral position has been adopted by the Supreme Court. The Brackeen case was also very interesting to me. I wrote this book that came out last year, very good timing, called Classified, The Untold Story of Racial Classification in America. And one of the chapters is about American Indian law and how American Indians are classified, and it's a complete mess. Sometimes it's tribal membership, sometimes it's blood quantum, sometimes it's affiliation with a community, sometimes living on a reservation. And my favorite, and anyone else that the Secretary of the Interior deems to be an Indian. So the Secretary of the Interior could, for some statutes, just decide people are. But there are several issues in Brackeen that weren't resolved. One is the one that Gail mentioned. Are we disadvantaging people because of their race? And she didn't get into detail about that, but I'll get into one detail. One issue with the case is that while it's supposedly a law it is in fact a law meant to preserve Indian families so they can preserve their culture, it goes well beyond that in the sense that, let's say you are a member of the Navajo tribe and you're in family court and a non-Navajo white family, let's say, is going to adopt you, and the Navajo tribe says, yeah, we've checked it out, we're okay with that. Any other tribe in the United States can then intervene in the case. I'm like, well, why is that? What does Sioux culture or Cherokee culture have to do with Navajo culture? Completely, it's like Germany versus Turkey or something like that, completely different, except for the race. So that's an issue. A related issue that I'm surprised I don't think was really raised, I haven't read all the briefs in the case. The issue in the case was, can the federal government have power over essentially local family law under the Indian Commerce Clause? But and they said it can, but what wasn't raised is, and can the federal government simply defer to the tribes as to who is an Indian and then take away people's rights based on that? Because the law says an Indian child under the law is anyone who is a tribal member or is eligible for tribal membership based on their parents' membership. And this could involve, and has involved in cases in the Supreme Court in the past, someone who is literally 256 Indian. One parent has inherited membership and is 6 1/28 or whatever it is, or 3 1/28, I guess, and the other parent is 100% non-Indian. So it's a little odd for the federal government to come in and say that because the Indian tribe says that they decide that you're a member or a potential member, that the fact that you're 253 out of 256 not Indian, that somehow your tribal culture, which you don't even have because your parents weren't involved in tribal affairs at all, gets to govern. The example I give, could the federal government just say, let's say the Navajo tribe, the Navajo Nation just announced everyone living within 20 miles of Navajo Nation is now a tribal member. Could the federal government then just take away or change your rights in state court on that basis? It can't be right. So I think that's another issue that should be raised. Another issue that's likely to come up in that case in the future, which wasn't raised, is that the impetus for the law were overzealous state officials taking too many Indian children away from their parents, partly as a way of assimilating them and to protect the parents and the child and the tribe. But in some of the cases that involve under this act, you have situations where there is a family, a partially Indian family, fully Indian, doesn't really matter. Their child's in foster care with a white or Asian or black family. They get to know the family. They like the family. They say, you know what, we're willing to give up our parental rights. We think these people would be great to raise our child. And then the kid who's been living with this family for 3 years is about to get adopted, and the tribe comes and says, no, we want the kid. And so this idea that the tribe has rights superior to those of the best interest of the child and of the child's natural parents, who have not had their parental rights terminated but have just agreed to terminate them, is also troubling, because what happens to the fundamental right to raise your children as you see fit, which the Supreme Court has also recognized. So that's what I have to say about those cases. I am going to mostly speak about SFFA, which I had a brief filed on my behalf in the case. I always tell people when they ask me to write amicus briefs, I want to write briefs, I would practice law rather than be a law professor. But in this case, someone said, well, I'll tell you what, I'll take your book and turn it into a brief, and you'll look it over and make sure it's good. And I said, fine. And we focused on the racial classification issue. The upshot of SFFA, I sort of disagree a little bit with Gail here in the sense that I think that what they did was reaffirm the legal standard from cases like Grutter, but they actually applied the legal standard. So the legal standard in Grutter and in Bakke and in Fisher is supposed to be that you're supposed to apply strict scrutiny, and strict scrutiny means that you have to show a compelling government interest, and you have to show that the law is narrowly tailored, the policy or rule is narrowly tailored to pursue that interest. And essentially in especially Fisher 2, the second Fisher case, and Grutter, in my humble opinion, the Supreme Court looked at the data that was available. It was obvious, especially in Grutter, that these were actual soft quotas. The same number of students from each group were being admitted year after year after year. They came up with this ridiculous phrase, which I always blank on, that you have enough of each group. What was it called?
A critical mass.
Critical mass. They came up with this ridiculous critical mass phrase. We have to have a critical mass of minority students, but of each group. But for some reason, the critical mass of Native Americans was 1%, the critical mass of Hispanics was 8%, the critical mass of African Americans was like 14%. That doesn't make any sense. Why would it be a different critical mass? It was complete nonsense. They just weren't really applying the standard, and here they really applied it. And they said, first of all, that while the universities and defendants, Harvard and UNC, purport to be pursuing a compelling interest in diversity, they haven't really explained to us, and they didn't really, what they mean by diversity and how that will actually enhance the educational benefit to anybody. Justice Thomas was especially vigorous on this point, but no one really, we're all in academia here. None of us really know what this is supposed to mean other than racial balancing, which you're not really allowed to do. The second thing they said is that you have to show that you've tried all non-race-based remedies to try to get to diversity, if that was truly a compelling interest. And it turns out that Harvard and UNC had not, and in Fisher they were very emphatic about this. You must try everything else before you go to race classifications. And it turns out that Harvard had never even thought about any other options other than using racial classification. They could have eliminated preferences for alumni, children. They could have eliminated preferences for certain kinds of sports. It wouldn't have gotten them all the way there, but it would have gotten them more diversity.
It wouldn't have helped at all.
Well, it depends how they did it. They could have done it, but anyway, they didn't. Regardless, they didn't even consider it. The attitude of universities, I'd say, in general, has been whatever the official reasoning of these opinions has been, as long as we don't officially say we're using quotas, they're going to leave us alone, so they just did whatever they wanted. But the third thing, which was the most interesting to me, given my interest in racial classifications, is that Chief Justice Roberts said, and the other aspect of narrow tailoring, which we've never actually focused on before, is that if you're going to use racial classification to achieve a goal, you have to explain to us why these classifications. You can't just say, well, Hispanic, African American, they're the official minority groups. Well, they may be the official minority groups for the census and for statistical purposes, but they were never intended as affirmative action classifications. You have to explain why like a white guy from Spain is getting a preference, or why a Hmong refugee child is not getting a preference, but the son of the dictator of some African country who came here for high school is African American if he gets citizenship and gets a preference, and they had not done that. Justice Sotomayor responded, well, everyone relies on these things, so why shouldn't, and the experts came up with them. Well, the experts, when they came up with them, specifically, I'll talk about this, said not to be used for affirmative act, as eligibility criteria. And in fact, the reason that everyone uses them is because the census uses them. So if you're going to be a social scientist and you want data, you either have to pay for a huge data set on your own, which will cost millions of dollars, or you just pay a few dollars to the Census Bureau and download their data and you use them, but not because they necessarily make sense. So anyway, let's talk about these classifications, because most of us, including me before I wrote my book, have no idea where these classifications came from. They're not natural or inevitable, but essentially in the mid-1970s, the federal government decided, we have civil rights enforcement, we have Great Society programs that we're trying to follow, we have voting rights enforcement, we have all sorts of things we want to track how different groups are doing, but we don't have any uniform criteria to decide. And meanwhile, we're coming under pressure from this one particular congressman from Texas who wants us specifically to figure out how to categorize people of Spanish-speaking origin. So the Nixon administration set up an interagency commission to figure out how are we going to classify people, because they were getting data that was apples and oranges. Some federal agencies, for example, were only tracking what they call Chicanos. Some Mexican Americans, some Mexican Americans and Puerto Ricans, some added Cubans, some used Spanish language household, some used Spanish, some of us are old enough to remember when Spanish surname was the common one and so forth. I think I counted 13 different permutations. There was Hispanic, there was Latino, there was Hispano. So let's come up with something. And it doesn't really matter exactly what we're going to come up with for two reasons. First of all, we're going to use these only for statistical purposes, especially to enforce discrimination laws. And for that purpose, whether we include people from Spain or not, whatever, it's a small population. If they see your name is Rodriguez on a form, when you apply for a job, they may discriminate against you anyway. So it's close enough for discrimination purposes, but also we have to remember that as of the 1970 census, the US was still overwhelmingly a black and white country. 82% or so of the American population was white on the census. About, I think it was 13% were black. Maybe it was 12% were black. 5% said that they were of Spanish-speaking origin, but Mexican Americans and other Spanish speakers had historically been considered white by the federal government. So they weren't really, they were considered more like an ethnic category, like Italians, rather than a separate racial category. And then less than 1% of the population was Asian or Hispanic. So while these classifications were not exactly scientific or even really thought out very well, there was, everyone in 1977 or so figured, well, we more or less, there are some cases on the margin. For the most part, we know who's white, we know who's black. You're white if you sort of are from European or the Middle East and you look that way, and you're black if you look like you have any discernible African ancestry. And that takes care of the vast majority of the population. What they did not anticipate was, number one, we'd have massive immigration over the next 45 years from South America and other Spanish and Central America and Mexico, from Asia, from Africa and the Caribbean, increasingly, and also that we'd have a much higher rate of interracial marriage. Interracial marriage used to be kind of rare. Now it's common. Here's an interesting statistic I'll just throw out. In 1958, that's not 40, that's not 14, 4% of Americans, the first time the Gallup poll asked, said they approved of interracial marriage. Now it's 95%, and for people under 30, it's like 98%. So this is a huge sea change that even in the 70s, it was only like 30%. So they didn't anticipate this huge rise in interracial marriage. So this has led to affirmative action programs having the seeds of their own legal destruction, right? Because the programs were originally created back in the 60s and 70s primarily as part of the civil rights movement. We've passed the Voting Rights Act, we've passed the Civil Rights Act, Fair Housing Act, but now we want to make sure that African Americans who've been excluded by hundreds of years of slavery and Jim Crow are able to integrate into the American economy and American society. And we can throw in some other groups here and there, but they're a small percent of the population. Who really cares? However, what happened? Let's talk. There's two major areas of affirmative action. One is government contracting. Gets a lot less attention in universities, maybe more important because there's a lot of money involved. And with university admissions, you don't go to Harvard, but you go to Tufts, less important to some extent. Anyway, in government contracting, the way the government contracting rules wound up being set up is that in order to get preferences in getting government contracts, you have to be a disadvantaged business enterprise. That wasn't clear what that meant. It was eventually resolved by the Small Business Administration, by the Department of Transportation, by the Housing and Urban Development Department, that disadvantaged business means you have under a certain amount of assets, and you are presumptively disadvantaged if you are a member of any of the minority groups, any of the non-white, if you're white, non-Hispanic, you're out, everyone else gets a preference. Now again, back in 1978, this was primarily African Americans going to benefit. Now, however, 2/3 of the people who fall into these categories, Asian Americans, Hispanic Americans, Native Americans, and Black Americans, are not African Americans. They're from one of the other groups. And even in the African American category, 21% of African Americans are first or second generation immigrants, and they have tended to be more upwardly mobile than the non-immigrant population, so they're also getting more of these contracts. So it's hard to get good figures on this, but I apparently inspired a Wall Street Journal editorialist to get the Wall Street Journal to do a FOIA request at the Federal Department of Transportation, which revealed that of all disadvantaged business enterprise dollars got from the Federal Department of Transportation, something like 8%, I think it was, go to African Americans. And if you exclude women from that and go to the minority groups, it was like 18%. So this program that was meant to help descendants of slaves and people whose ancestors lived through Jim Crow and the Civil Rights Movement and all that, very few of those are going to them. And again, the 18% is modified further. We don't have data on this, but it includes first and second generation immigrants as well. So by the way, this is a problem. If you're in favor of affirmative action in government contracting, right now about half the population is eligible, even putting aside the female preferences, just under minority business enterprise preferences. There's also a tremendous amount of exaggeration and fraud, think Elizabeth Warren, that goes on in these categories. So in another generation with more immigration and more intermarriage, and you don't have to be 100%, 50%, anyone who could justifiably claim I consider myself Asian or Hispanic or Black, whatever, could check the box. It's going to be like 80%. If 80% of people are getting a preference, it's not really a preference anymore. So affirmative action will wind up on its own anyway. In the educational context, we had a bit of a different trajectory because Justice Powell, as Gail already said that the watchword here is diversity. So universities said, okay, we will therefore look for a diverse class in general. We're primarily interested in African Americans, but we also at Hispanics, and originally Asians were often eligible as well. If you look at Bakke, Asians were included in the Bakke quota that the court considered. If you look at the case before that, to Funes, which was the court decided it was moot, that got to the Supreme Court. In that case, the University of Washington Law School included Filipinos in there, but not other Asians in their affirmative action programs. In any event, eventually what happened was that Hispanics became a larger and larger percent of the population. So now 25% of American 18-year-olds are Hispanic, compared to 15% are African American. So now more Hispanics and African Americans are benefiting, even if they don't get quite as high a preference. But also Asian Americans were deemed overrepresented eventually, and they face some amount of discrimination in many elite schools because they don't want to have too many Asian Americans. Doesn't look good in their brochures, they think, and so forth. In fact, one of the very telling statistics in the Harvard litigation is that in 1990, Harvard's entering class was 21% Asian American, and in 2014, when the SFFA litigation started, it was 22%, despite a very large increase in the Asian American population, and especially the native-born Asian American population. In other words, native English speakers would be more likely to be able to get into somewhere like Harvard. In any event, this led to a lot of awkwardness in these classifications. So, for example, in the University of Texas, Fisher University of Texas case, University of Texas, there's not a very large black population in Texas. There's a lot of Hispanics, mostly Mexican Americans. And if you look at what was going on there, the action was really, are we going to have more Asians and fewer Hispanics, or vice versa? And you wind up with this weird situation because Asian American is such a broad classification that you could have someone who says, hey, I'm a Hmong, a Cambodian, child of refugees from Minnesota. I heard you're interested in diversity. I want to be admitted to your university. As far as I can tell, you've never had a Hmong student ever. And the University of Texas says, sorry, you're Asian American. And we already have more than enough of you. And then they already have 3,000 Mexican Americans, and the 3,000 first applies. So yes, you're adding to diversity. It doesn't make any sense. Meanwhile, we have the immigration from the Caribbean and Africa. And I always like to, I don't always say this, but I point out once in a while that sometimes the people who are benefiting from affirmative action not only are not the descendants of slaves, they're descendants of the slavers. Remember, there were people who were in Africa who were selling the slaves to the European slavers who stayed there, and some of their ancestors descendants are now getting affirmative action. At Harvard, 20 years ago, and you have to think it's even more now, there was an article in the New York Times saying that 67% of the black students at Harvard were either descendants of first or second generation immigrants, or to a lesser degree had one non-black parent. And with interracial marriage increasing also, there's more of that. So why do I think this is all important for affirmative action creating its own legal demise? Well, first of all, like I said, in the case of contracting, it's going to become so common that it's going to be hard to explain why you're giving 70 or 80% of the population government contract benefits. But in the case of universities, I think that, as Gail mentioned with regard to Powell, it's a very interesting phenomenon. But every time people thought the Supreme Court was poised to say, that's it, no more racial preferences, period, the most moderate establishment type Republican justice on the court would sort of, at the last minute, seemingly change his or her mind. So Powell and Bakke was the fifth vote. O'Connor and Grutter was the fifth vote. In the two big government contracting cases, Scalia wanted to say no preferences, period. Kennedy and O'Connor wrote a concurring opinion giving enough wiggle room that the various jurisdictions ran a truck through it. Even Justice Kennedy, who had consistently voted against affirmative action every single time, when it was his turn to be the fifth vote in Fisher, decided not to go that way. And I think there's I don't know if it's a good reason, but an understandable, at least, reason for this, which is that affirmative action was indeed part of the outgrowth of the civil rights movement, meant to bring African Americans into the economic and social mainstream after generations where they were excluded. And it was very symbolically troubling to say we're not going to do that anymore. And judges of a conservative temperament and a moderate temperament didn't want to be the one to cast that deciding vote. So why didn't that work with, say, Kavanaugh and or Roberts in this case? And I think it could just be that they're more conservative than their colleagues on this issue. But I think there's two other things. One thing I think is that each time the court restricted things more, the universities just said, as I mentioned earlier, we're just going to do whatever we want as long as we don't have formal quotas. And that kind of got annoying. But I think the second thing is that if you look at the data, it shows that in contracting particularly, but even in university affirmative action, the vast majority of the beneficiaries aren't the people that we were worried about to begin with. It's not what some people called ADOS, American Descendants of Slaves. It's Hispanics, it's It's people who at least check the Native American boxes. Tremendous fraud in that regard. It's first and second generation African immigrants. So it's less daunting to say, well, we don't really need this anymore. Well, what is exactly the point? There's probably much better ways of achieving gains for that population than to prefer 80 or 85% of the benefits going not to them, but to post-1965 immigrants. So, of course, there's a lot more one could say about this. There's all sorts of issues involving what will the court do if universities are using things that seem like proxies for race. There's issues about, well, how will this classification skepticism manifests itself in other areas. If I had more time, I'd go on about how the FDA and NIH use these classifications, require biomedical researchers to use classifications like Hispanic or Asian that have absolutely no scientific basis and involve groups that are extremely internally genetically diverse. But I'll leave it there for now and let there be questions.
Footnotes 2, 4, and 8 have interesting issues.
I have to admit not knowing offhand which footnotes those are.
Yeah, so footnote 2, let's start with footnote 2. So this I thought was kind of wild because this was where they explain why they're not going to go the Title VI route, the statutory route. And the case is 6-3. So in order to explain why Harvard is subject to this, they have to explain why Title VI means what they say it means. And two justices, Gorsuch and Thomas, have said they think Title VI was misconstrued by 5 of the justices in 1978. But the court says, and to be the court, it has to include Gorsuch and Thomas to get to 5 votes. The court says in footnote 2, well, in 1978, we said that Title VI doesn't prohibits exactly the same stuff that 14th Amendment prohibits. So because North Carolina is subject to this duty, so is Harvard. Although Gorsuch has some reasons to depart from this, none of the parties raise it, so we're not going to deal with it. I mean, it really seems like Justice Gorsuch and Thomas are criticizing themselves by joining that footnote, criticizing their concurrence. Is that?
Well,
is that as bizarre as I think it is?
No, I think that they're going off on this notion that it wasn't briefed by the actual parties. It was briefed by the amicus big time. So I don't quite understand, why they feel that I don't quite understand why the petitioners in the first place, the plaintiffs in the first place, didn't go for it. As I've said, I think they should have. I think that at this point, see, in Bakke, what the argument was they looked back through the legislative history, and they found a couple of situations where somebody says in Congress, all Title VI will do is that it will apply the Constitution to federal funding recipients, and that was latched onto as C. All they're saying is that they're trying to track the Constitution. But each one of the speakers who said that believed that the Constitution was a flat ban on race discrimination. So it was not meant to be a notion of we're only applying, this looser standard. To the contrary, they're thinking belt and suspenders with regard to state universities, that a state university has a flat ban on race discrimination that comes from the Constitution, plus now they will have Title VI. And that was the whole argument, and I think it's a zero argument. It's perfectly clear that in 1964, members of Congress, having read Brown versus the Board of Education, which is kind of soft on that issue, and then reading cases like Browder versus Gale, which is not soft at all on the issue. Browder versus Gale was a case involving race discrimination in public transportation, in buses. Montgomery bus boycott cases. And while Brown versus the Board of Education was a little squishy and said, look, segregation in the context of education is unconstitutional. Browder versus Gale is just saying, look at you, this is race discrimination again, and in like a single sentence disposes of the case. And so in 1964, they're thinking that the Supreme Court agrees that there's a flat ban on race discrimination, and that's all they meant by that.
Any thought on Title VI?
My only thought is, I mean, there was a Justice Thomas and I think it was Justice Jackson go back and forth on the originalism point about whether the 14th Amendment could have been construed to allow for racial classification, at least for benign purposes. But one that just raises one particularly interesting issue for me. First of all, I mean, I've blogged about this a little bit, but if you agree that when the Reconstruction Congress was allowing for particular benefits from the Freedmen's Bureau and whatnot, it wasn't just that they were formerly freed, former slaves and all that. It is the equivalent of a race classification. My rejoinder to that, in a sense, is that it actually is an interesting argument for allowing specifically race-based classifications for African Americans. I'm not sure why it would allow for someone who someone who immigrated from Argentina of Italian descent for his children to get preferences. But also it raises a related issue for me, which I sort of thought about towards the end of writing my book, but Justice Kavanaugh actually asked about this in oral argument, and I think Harvard may be thinking of going this route, which is in fact being a descendant of American slaves, legally speaking, a racial classification. It probably would be for Title VI purposes, pretty obviously. For 14th Amendment purposes, I'm not sure, and it's not even a question of what I think philosophically about that, is that there's a decision from 1974 called Borden versus Moncari involving American Indians, where the Supreme Court said that a racial classification, preferences for members of American Indian tribes are not racial classifications. They said there's an overlap between being a tribal member and being racially American Indian, but not all people who are racially American Indians are members of tribes, and there are even some people who are members of tribes who are not racially at all American Indians. Similarly, one could argue with over 20% of the African American population not being descendants of slaves. Once again, there is an overlap between being a descendant of slaves and being black, being a black American, but it's not exact, and there are historical political ramifications of that that wouldn't apply to other groups. So we'll see. Kavanaugh asked the plaintiffs whether that would be racial, and they said absolutely, but no one's bound by that. And at least he was sufficiently interested in that to ask, so we'll see what happens.
Okay. Well, footnote 4 was the West Point footnote saying military academies come in and say it's important to have racial classifications for a diverse officer corps. However, they're not parties before the court. And this struck me as a really broad possible loophole because I'm looking at it thinking, well, what are we going to do? He said, well, you know who else isn't a party before the court? The University of Mississippi. And then footnote 8 says why they're not going to give much attention in the opinion to remedial rationales. They say because the parties don't raise a remedial rationale. So it seems nationwide like there aren't a whole lot of state institutions. I'm not sure there's any that have explicitly said, we're going to try to run, we're going to see those as big loopholes and try to run through them. Have you heard about people trying to run through 4 or 8 as the I guess West Point itself is probably
to go back what I said earlier, they didn't overrule the test of compelling interest, and they said there might actually be compelling interest. I don't recall they said that I don't think they said the military would be one, but I think they referenced, or maybe it was referenced in one of the briefs. I forget, frankly, at this point. But I think the issue was, well, in the 1960s, there was serious racial issues in some units of the Army, and part of it was integrated or mostly black units had white commanders, and the Army felt very strongly that we needed more black officers to mitigate that. And I think what they're really saying there is true national security concerns, that if we believe that they are real, would be a compelling interest. The other example they gave, which I think is, I don't know how Gail feels about one, but strikes me as at least reasonable is there have been situations in the past where there have been race riots in prisons because some fraction of the black prisoners and the white prisoners and sometimes the Latino prisoners belong to race or ethnicity-based prison gangs. And the states have said, okay, let's separate these groups temporarily until things calm down. But that we are directly saving people's lives, and we're not going to do this indefinitely, but we will do this while until we could quell whatever, figure out which prisoners we need to transfer out to stop this, and then we could reintegrate everybody. And again, that doesn't strike me as an unreasonable, compelling interest for the court to consider.
Well, that's kind of the classic, what will survive strict scrutiny? The prison race riot, where there is a riot going on. And even back in the 1970s, when constitutional scholars like Gerald Gunther were saying, look, strict scrutiny is strict in theory, but it's fatal in fact. And this goes back to what I was saying a minute ago, that in 1964, members of Congress, when they were saying that Title VI just applies the Constitution to federal funding recipients, that's because they thought the Constitution absolutely banned discrimination and on the basis of race, and it wasn't until a few years later that you were getting a trend in the opposite direction. On the military academy thing, what I wanted to say was back in 2003, when the Grutter case and Gratz versus Bollinger were being litigated, there was a famous amicus brief that got tons of publicity that was based exactly on this issue. And it was like every newspaper was reporting about this amicus brief. And I was thinking, why don't my amicus briefs get that much attention? Although now that Clarence Thomas has cited me on my amicus brief, I'm happy again. But at any rate, back in 2003, this military academy brief was getting so much attention. I think that it was probably on somebody's mind that's in the majority that wanted to say, but let's not suggest, that the military academies would be covered. I don't see why they wouldn't be covered. But sure, the law can be messy. And instead of hearing about reaction of the military academies, what I'm hearing now is people talking about queuing, that case up for the Supreme Court, which seems like an odd case to go after because it's a very isolated issue. And I think there are different considerations in the military academy. I don't think it's going to go. I don't think it should go the other way, but maybe it would.
The fact that we pick one person from each congressional district to go to the military is already
highly
suggested.
political.
Yes.
To me, it becomes, kind of like going after the issue of the President of the United States says, I'm going to appoint an African-American woman to the Supreme Court, and people say, well, isn't that unconstitutional? No court's going to touch that with a 10-foot pole. That's a political decision that they're going to say is just not justiciable. They're not going to tell,
Yeah, Reagan in 1980, when he was campaigning, he's like, I'm going to put a woman on the Supreme Court.
It
was just part of one of his standard things he put in his stump speech.
Yeah, I find it distasteful. However, I also, if I were a judge, would find it no, I don't want to deal with that.
So one way to deal with those would be to say, and Morton versus Mancari would be to say, well, just political appointments are per se excluded from our anti-discrimination rule. The anti-discrimination rule only applies to...
You don't want to say they don't apply. You want to
justiciable.
say that they're not justiciable, that it's going to, it's...
If you look at the history, if you look at the Reconstruction history, the distinction between civil rights and political rights is just repeated over and over. And it would be extraordinarily distasteful as just a matter of public norms to say we're going to make appointments on a racial basis. But if you look at the history of the 14th Amendment, they say, well, as long as you're not actually changing what's the civil rights that people enjoy. Civil rights are the ability to be treated the right way by the government. Political rights are the right to control the government. So Morton is about officers in the Bureau of Indian Affairs, and they say we're just going to prefer people with certain ancestry. You could make an argument that officers are you can pick them that way, and it's not per se affecting people's civil rights. But that, this is fighting wars that were lost in 1927 and Nixon, not the President Nixon, but the Nixon racial discrimination in voting as applies to the 14th Amendment. So which is fine with me. I mean, I'm always like, well, they were wrong, so let's fix it. But I certainly understand. I'm against the zeitgeist as it's been for a long time.
By the way, on the remedial rationale issue there, I am reading them to say, they're talking about remedies that are specific to the institution. So past discrimination by that particular institution, and not the past, generalized societal discrimination that Lewis Powell, to his credit, rejected in the Baki case. Although he's writing that for himself, that's a one justice decision.
So, Dean, you wanted to jump up and invite people to sue us? I hope not.
I was going to follow up with that comment about institutional discrimination and ask the question, how long ago would an institution have to show that it was discriminating? Because obviously here at the University of Mississippi and in this law school, there is a history of intentional discrimination based on race to keep black students from attending. What's the temporal sort of argument?
And all I can say is, I don't know, because that's an issue that's important. How long can these things go on? And to go back to the redistricting case, where Kavanaugh brings up, the possibility of, when can disparate impact analysis be used? And one of the problems, it's a different context, but it's something at least he talked about. One of the problems here is that when it comes to issues like disparate impact, everything has a disparate impact on some protected group. It's not always the same group, but there's always going to be some disparate impact. Now, Kavanaugh's talking about it in the context of the Voting Rights Act. So he's talking about disparate impact of any sort of rule that deals with who votes and where we draw district lines and such. I usually talk about it in the context of Title VII, where we're talking about job qualifications. Every job qualification has a disparate impact on some group. It's not always the same group. I mean, for goodness sake, if you're looking to hire manicurists, then guess what? Vietnamese Americans are going to have a leg up if you want somebody who has some experience as a manicurist, because I don't know if you've noticed, but across the country at this point, Vietnamese Americans are disproportionately working as manicurists, and there's an oddball reason for that, and I bet you don't know what it is. After the fall of Saigon, they set up refugee camps in California, and they wanted to get people to work as quickly as possible and get them out of the refugee camps. And Tippi Hedren, the actress who was the star of The Birds, she goes to visit the refugee camps, as a goodwill, and she's got great manicure, which I don't have, so I shouldn't show my fingers. And the girls, some of the young girls, admire it, and a light bulb goes on over her head, and she thinks, how long does it take to learn to be a manicurist? There's like a course that takes just a few weeks. And so she financed a handful of these young women and got them jobs. And those young women saved their money. They told their sisters, here's a job that you can do even if your English isn't that great. And the rest is history. And you'll see that for like every job. Everything has a disparate impact. And the same thing's going to be true for any kind of voting rights rule. Everything will have some disparate impact. And Kavanaugh's asking, we do this because we know that there is some intentional discrimination. And so we cast a wider net and get things even that might not be so intentional. But how long can you do that? How long can you keep going on that if you feel that the level of intentional discrimination has vastly decreased, as I think it has? And the University of Mississippi is not discriminating on the basis of race. It's been a while now. How long can you continue to have the possibility of past discrimination justifying remedial? Maybe it's long over, and I would submit that maybe it should be regarded as over at this point.
Let me add a little bit there. So one thing I didn't say about SFFA that I maybe could have or should have is that another factor that was in the opinion is that even if you pass all the compelling interest, narrow tailoring tests, there has to be some plan with a time limit. It can't, apparently, they suggest it can't be indefinite. So that goes to time. But I think two other things on the dean's question. The first is that to the extent the university wanted to do this, one has to be careful about which groups one is talking about. So Justice Sotomayor said in her dissent, the University of North Carolina was a whites-only institution until the 1960s. That is actually false. The University of North Carolina had admitted Chinese students in the 1890s. They'd always admitted American Indian students. They excluded African American students. They were not a whites-only institution. And to the extent the University of North Carolina can make some sort of case that they want a remedial program to compensate for the former and continuing effects of discrimination, they would have to limit it to the group they actually discriminate against, not people of color or some other phrase more generally. Relatedly, where this also comes up is in the context of government contracting, because what when I said that Kennedy and O'Connor left a loophole that the government's at all levels drove a truck through, and now there's more of this than ever. What they said was, well, you're not allowed to just do this for racial balancing purposes, but what you are allowed to do is if you find that there was historical discrimination in your jurisdiction and it has continuing ramifications today in the field of contracting, not generally, then you could have these preferences. And after Croson and Adirondack, there were dozens of lawsuits against counties and cities and states, and every single one of them, the defendants lost. So then they got wise and they started hiring consulting companies to do disparity studies, which were, normally you want to show when you're doing a study that you're not discriminating anymore. These were intended to show, they were intended to justify the underlying policies. In fact, there are these weird interviews where they do with the San Francisco Board of Supervisors, most liberal jurisdiction. Oh yes, we discriminate all the time. We don't want any minorities getting any jobs. All right, whatever. Now those would also initially people would sue over those also. And the one easy way they would win is if they included groups that were never really discriminated against in the program. Well, you have this disparity study showing you discriminate against black people, but why are you including Native Americans or Asian Americans? But also they usually would win these cases too, and then what would happen? The jurisdiction would just make a new disparity, say, well, that wasn't a great disparity, so let's do a new one. And eventually what happened was that the Association of General Contractors, which was bringing these lawsuits, either their state affiliates or their national organization, said, we're in an endless loop here. They're just going to keep doing new disparity things. We're wasting money. And I think the actual contractors who are urging them to do this figured out something else. We could keep bringing these lawsuits, but if we're in a position where it really matters to whether we're getting contracts or not, whether we qualify, we could do one of three things. One of which is we could remember that we have a great-grandfather came from Mexico and just check the Hispanic box or some other ancestor and then get minority status ourselves. Number two, we could buy membership either buy membership in a Native American tribe or in Louisiana and a few other places, we'll just make up tribes and have the legislature endorse them. And then we could say we're tribal members, which is, someone needs to write a book about that because that's a fascinating thing. Or the third thing is, or we could just, because women are usually eligible for these preferences too, we'll just put the business in the name of our wife.
Yeah, everybody's daughter now owns their business.
Right, and hope we don't get divorced.
Yeah, the Adirondack, the Department of Transportation type stuff, because it was, a lot of those were geared to minority ownership, right? If you can just transfer your interest and just use somebody else as a shell. It didn't have anything to do with the employees or kind of who was doing the work.
There are also figurehead things. So the long story short, that litigation should have eventually led to some real precedent on how far back the discrimination go, what evidence you need. But because of the way it worked out, we don't really know.
Cade.
Cade Smith. I work in the Division of Diversity and Community Engagement, and let's say at the University of Mississippi, we look back over the previous 15 years and we see that when we control for academic preparedness by standardized test scores and perhaps family income, we see differential outcomes by race on student success. So let's say that when we control for preparedness and income, that black students successfully graduate at a lower rate than apples to apples comparisons for white students. Would that be justification for differential allocation of resources to try to change those outcomes in success?
I'm just wondering if you've successfully controlled for preparedness, and that's key here, because my guess is when I'm looking at numbers, I'm usually finding the opposite, and that is when you control for preparedness, then what I mean by that is using standardized test scores,
Right.
And to the extent you can, using comparable things like high school GPA, comparable, not just. And I'd be surprised if you're getting big gaps if you're successfully controlling for preparedness.
And so let's say that we are, particularly at for ACT, at the lower quartile ACT.
Are you using continuous variables, or are you just using bands?
So using discrete ACT aggregate scores. And so this is a hypothetical. So let's say we do multivariate regression analysis, probit analysis, controlling for those variables, and we still see differential outcomes.
Well, let's make it easy. Let's assume it's not even contested.
Yeah,
Litigation that we have,
right.
whether we can do it, right?
And would that be justification for using racial preferences in the allocation of resources to change those outcomes?
You're talking about using it in terms of more remedial money spent.
Yes.
Is it-
Resources spent, relationships, interventions, et cetera. Yes.
It sounds like a bad idea to me. It sounds like a bad idea because it opens the door to something that I think is a problem, but it's at least an interesting question.
One thing there that you would, the doctrine would require would be something causal about the ability to use differential. Making the distinction would have to have some. You'd have to have some reason to think this was going to help, and the mere correlation you need. I mean, if you control with enough stuff, you can kind of infer that there's a causal element, but that would be just kind of conceptually, that would be a key jump that in a certain circumstance you could imagine somebody pushing back against, I think.
Gail's not going to like this answer, but I would think that if you had that data and you could also tie it to this being a historically white supremacist institution and that there is some evidence of an actual hostile environment that makes it more difficult for black students to succeed, it would likely be considered a compelling interest as long as you narrowly tailor it, where you're really focusing on those students who are struggling and so forth. But if I were the general counsel's office, I would say do that, except don't say that it's only open to black students. Say this is specifically geared towards this particular cohort of students who are struggling, but it's open to everyone. You'll still wind up getting 80 or 90% of the black students coming, and you'll be much less likely to get sued.
This reminds me of some data I was looking at recently about maternal mortality. The argument has been that African American women are much more likely to die in childbirth, although I should footnote here, very few women die in childbirth these days. And if you look at the time, this over history, it's been basically a miracle. In like 120 years, we've reduced the number of mothers who die in childbirth by like 99 point something %. But nevertheless, African American women, if you just look at basic numbers, are more likely to die in childbirth than whites. Although, interestingly, the racial makeup doesn't go quite the way that it usually does, in the sense that the least likely to die in childbirth are Asian American women, followed by Hispanic women. And that white women die in childbirth more often than Hispanic women, but African American women. But basically, if you take it and you control for only a couple of things, race will continue to be a factor. But if you're more careful with your controls, it isn't. And you can better target by looking for diabetic status, weight not only, and weight is kind of an odd issue here, in that white women are more likely to be morbidly obese than Hispanic women, based on the numbers that I've seen. On the other hand, to be slightly overweight, Hispanic women were more likely to be slightly overweight than white women, and both those things matter. When you control for everything, race drops out, as you would expect. But if you only control for a couple things, then race doesn't drop out. And I would submit it's better to get, to target the people who are most at risk than it is to say, well, we'll only control for a couple of things and we'll take the lazy way out and say that race is actually a factor here.
I just can't resist adding this. One thing I came across in the research for my book, I came across all sorts of interesting things that I didn't elaborate on because they were tangential, and this is one of them, that in California, but it's true nationwide, but I have a really good data for California. In California, Asian Americans, which is aggregate category, but still have by far the highest life expectancy, followed by Hispanics, then whites and African Americans. And and Asian Americans are less likely to be insured than whites are, but Hispanic Californians are particularly much more likely to live in poverty and much less likely to have health insurance than whites, yet they have a longer lifespan. And I did some research. I was like, oh, this is very, not really relevant to my book, but kind of interesting. So I just was looking around, and people have noticed this, and all sorts of people have tried to study it. And the consensus in the medical community as to why this is true is we have no idea.
It's a complicated world.
Any final questions? Got a couple minutes. So my recent work that I've been doing on kind of equal citizenship requirements, I have several areas of the law where I'm thinking that we should model it on administrative law from Citizens to Preserve Overton Park. So the case about having to have a better reason for putting so when I-40 is going through Memphis, they decide to they're initially just going to plow through Overton Park, and they say, oh my goodness, you're going to cut off the zoo from Overton Park. You need a better reason than that. So it seems to me there's good historical support for the idea that to be a citizen is to be worthy of fair and impartial regard for one's interest, just like the Citizens to Preserve Overton Park deserve fair and impartial attention, and therefore an adequate explanation given whatever the data is, data are, maybe if you want to say that. And that's going to just change over time. So how good an explanation are you going to need? It's going to depend on how fine-grained we're able to do, what we're able to control for, whether these categories make any sense, and all the things like that. So.
All right.
Happy Constitution Day.
Yeah, thank you for coming, everyone. Let's thank our panelists.